Avoid wrongful termination lawsuits. What is constructive discharge? My name is Mike Vannoy. I'm the Vice President of Marketing at Asure. And this is a really important topic that we're going to unpack today, this notion of constructive discharge. It's a legal term. And I think this is what trips people up, because so many employers work in, say, an at-will state that they think if there's, whatever reason is justifiable to them, they're not trying to be inhumane, but they can terminate employment. But there are some legal constraints here, and just because you can terminate someone against their will doesn't mean that they can't sue you for any reason they want for wrongful termination. And constructive discharge is one of the most common reasons that people sue for wrongful termination. So to help me unpack this topic, today's guest, if you're a regular attender of the show, Brian Shenker. He's a counsel of the Long Island, New York office of Jackson Lewis P.C. Brian's practice focuses on representing employers in a wide range of workplace matters, as well as preventative advice and counseling. Brian has extensive experience defending class action and collective action lawsuits under federal, state, and wage and hour laws. He has successfully defended wage and hour audits conducted by the U.S. and New York State's state departments of labor. And Brian regularly handles cases before courts and administrative agencies involving claims of discrimination, sexual harassment, and retaliation. Brian, welcome back to the show.
Thanks, Mike, for having me. A very interesting doctrine that we have to discuss today, constructive discharge. Something that many employers may simply be unaware of. So I think unpacking this today will be certainly interesting.
So let's just start out with kind of like a definition. I think legal and practical. What is constructive discharge? I think this is a term a lot of employers haven't heard of.
Right. So the Supreme Court has defined this doctrine as an employee's reasonable decision to resign because of unendurable working conditions, so that it's equated with a formal discharge by the employer. So essentially, it's a claim that when the employee quits, that the law will treat that as an actual termination by the employer. So at its most basic level, the inquiry that we're looking at is, did the employer create work conditions that were so intolerable that a reasonable position in that employee's shoes would have felt compelled to resign? Yeah. So as you mentioned, this normally comes into play, in the discrimination, hostile work environment, retaliation context, both at the federal, state, and even the local law. This doctrine is typically recognized.
So Brian, from a legal perspective, this is not like it's there's not a line from Title VII. There's not a law that spells this out. This is that say Department of Labor enforces, say, like wage and hour, overtime, minimum wage, things like that. But this is a legal thing that the courts will defend when it comes time to wrongful termination. So the way this plays out is lawsuits, right?
Exactly. So, right, this isn't actually, in most statutes, it's not actually on the books. The history comes from actually the union context. So this cause of action, the constructive discharge claim, was first recognized in the 1930s by the National Labor Relations Board, and they interpret the NLRA, the National Labor Relations Act. So back in 1938, right, among other things that were prohibited under the NLRA, you can't fire an employee because they joined a union. So after the NLRB passed that, had that law in the books, employers smartened up, and the NLRB realized that the unlawful firings they sought to stop were being just as easily achieved by employers who made conditions of employment so bad that many of these workers were forced to quit. So the employer could claim to the NLRB, hey, they voluntarily resigned, but at the same time, the employer was doing everything in its power to force that resignation. So,
Right.
they were following the letter of the law, but certainly, not the spirit. So then in this 1938 case, the NLRB held that an employee ran afoul of the act when it fired, not only when it fired an employee, but when it purposely made conditions so bad that the employee had no meaningful choice. And that even if they quit in such circumstances, they would still have grounds for a wrongful termination claim. Just as, someone who was actually, terminated. So, within decades of that decision, courts picked up on it, both federal and state courts. And now it's a recognized doctrine, all throughout the country, that an employee can resign and still assert a claim.
Okay.
So,
So
we look at it as, the exception to the rule, but, certainly, it's well established at this point.
So most people watching today's show or listening after the fact probably think, well, I'm not a jerk. I don't. I have employees that maybe I don't like, and maybe they're not productive, or I don't need them anymore, and so I need to let them go. But I'm not a jerk that just creates quote unquote intolerable situations. Let's get into the details. What do I understand it right that there's a 3-part test that the courts will look at to determine whether this does qualify as constructive discharge?
Right. So in general, there are 3 parts to this, and that number one, working conditions must be such that a reasonable person in this employee's position would find them to be intolerable, and the intolerable working conditions must be a result of conduct that relates to the underlying discrimination claim or retaliation claim, and then obviously the involuntary resignation. This results specifically from those intolerable work conditions. So it might even help to put this in context to back up a step. Right, to understand how constructive discharge works, let's look at what a discrimination claim requires in the first place, right? So typically the burden is on the employee to establish a prima facie claim of discrimination, which includes, one, that they belong to a protected class, right? This is race, sex, religion, disability. 2, that the individual is qualified for the position. And then 3, that they suffered an adverse employment action. And then finally, that adverse employment action occurred under circumstances giving rise, to an inference of discrimination. So looking at that, the constructive discharge doctrine is essentially another way to satisfy the adverse employment action, that, conditions are so bad that, again, we're saying instead of needing a termination, I can just point to these bad conditions that force me to, quit as being that adverse, action. But, again, as we'll go through and I'll use some examples, this often requires more than just regular discrimination, more than just, ordinary hostile work environment. To some extent, we talk about it as, hostile work environment plus, right? So there's the hostile work environment that might give rise to the employee's actual underlying claim. But to get to the level of a constructive discharge, there's got to be something else. What's that egregious conduct that pushed this over the edge, into to force this person to quit? So,
let's talk about that, because you can't say, hey, these are intolerably hot conditions, I can't take the heat. Well, it's a roofer in Florida, right? I mean, it's hot. That the job is, and it's not different than anybody else doing the job. So maybe give us some examples, or what's the clarification of intolerable? Because I assume it has to do with intolerable that is unique to that person in a different standard for everybody else.
Right. No, exactly. And look, there are probably 2 main broad categories of scenarios this comes up in when we're talking about the employer's conduct. One is where the employer makes it clear that essentially no matter what the employee does, they're going to be terminated, right? So that you've just left them with in a position where, for instance, they're placed on a performance improvement plan and told that when, the 60-day time limit on that runs out, that the company will terminate them no matter what. Right now, obviously, we're talking about there's a background of some discrimination or hostile work environment there. But if that employee resigns before the end of that 60-day period, right, that could potentially be a constructive discharge because they were left with a little choice, right? You're either going to quit or be fired, which isn't a real choice at all. The other scenarios where this comes into play are where the employer's conduct really becomes so intolerable that it pushes the employee to make that decision. So, to give you an example, this actually comes, just right from the EEOC. That, for instance, you have an employee who is black and they're employed as an assembly line worker and required to work closely with others on that assembly line. That employee is subject to repeated harassment from other white employees on that assembly line, such as racial jokes, racial slurs, even going so far to tamper machinery that this employee works with to interfere with his job performance. That employee then complains to the company or to his supervisors, but no action is taken and the comments continue. Look, oftentimes we've seen this before. A manager or supervisor might think it's funny. That it's just everyone's having good fun, but this individual's complained, it clearly isn't. And then that individual then, because he's now complained, it hasn't stopped, it's continuing, he now resigns and files a charge of discrimination. So that employee is going to contend that he was subjected to this racial harassment and that his resignation was in response to that, and that the thing that took this beyond just the regular discrimination was that even after he complained to the company and the company had noticed that something was going on, they allowed it to continue. So, that's one example, where we could see, a constructive discharge claim. And, the EEOC identifies a number of relevant factors that it will look for in determining whether this rises to the level of a constructive discharge. So first off, they're going to look at, what the employee gave as the reason for resigning. Because, right, obviously the resignation has to be because of this conduct.
Yeah.
Two, obviously they're looking at the actual discriminatory employment practices that are alleged. But a very key element is how long the employee was subject to these, this conduct. Someone who quits after, 2 days of unwelcome advancements or unwelcome comments, that often is not going to be looked at as being severe enough in terms of the amount of time the employee had to, suffer through this to lead to a termination. So, one big question is how long, and then the timing. Many courts have found that, if there's anything that in the employment that actually improves right before the employee's resignation, that can defeat a constructive discharge claim because that would indicate that things weren't so bad. So it's a very fact-intensive inquiry. And again, one of the biggest things, and we'll get to this later on, is that, one of the typical requirements in a constructive discharge claim is that the company knew about it, that the employee made a complaint, that the company had this opportunity to understand what conduct was being alleged, and then we're either going to see that the company did nothing and it just continued, or the company maybe did something but then engaged in retaliation. Those are the types of things that will, inaction or inappropriate action, can lead to these types of constructive discharge claims.
Brian, I got to think about how to even ask this. So like I assume people watching and listening to this they don't see themselves as a racist, and these cases are probably not blatant, racial epithets being thrown around, right? But to follow up on the use case that you gave, pretty common in some job environments that there's like some rookie hazing, right? That happens, and what about situations where the employer thinks this is just in good fun, and maybe some of the comments were not super blatant that everyone would obviously agree, no, that's not acceptable, but there are more nuanced cultural references that your use case, the black man, deeply offended by them, right? And probably rightly so, but the offense isn't intended. It's meant to be all good fun, shucks, let's pick on the new guy. Help employers to understand where they must lie on this continuum of because we're by definition, I think, gray area legally. Give some guidance for employers in that situation.
Yeah, and look, I think it's, there's a spectrum, right? There might be some, level of, I don't want to say hazing, because I don't think there's any level of hazing, that's appropriate, but of, friendly, behavior in the workplace. But yeah, I think, we always go back to having the right policies in place, but, a lot of it's about setting, the right tone for your company, having the right company culture. Another, recent matter, involved, a retailer, that we would all know, in the fast food industry. And, there, it's similar to what you're saying, there was a toxic workplace environment, the EEOC found, right? With, the male service managers and, harassing young female crew members at a particular location. And there, the EEOC looked back and said, yeah, there's, we have a history of this, right? Where, there's a history of some unwelcome sexual comments, things like that, where again, these are young people in their 20s that, the company might have just thought, this is normal behavior and, we're allowing it, that, young people can talk to each other. But, what did happen is an employee complained, and the general manager then failed to investigate, and instead turned the investigation around and thought that it was more about, this, female who complained having a consensual relationship with a manager. And so that's how the company looked at it. And so, this harassment, this, whole environment continued. And then, a year later, again, more comments, calling someone, mama, sweetheart, baby girl, things like that, where, more comments were made, another complaint was made by two individuals, and nothing was done. And so those people then, quit, especially after, there was some, we'll say not quite retaliation, but the individual who is alleged to have harassed found out about the complaints, starts making comments to the people who complained. And, that the EEOC found was sufficient for a constructive discharge. So, that's one where, the conduct isn't necessarily, as egregious as, many examples we could come up with, but the fact the company knew it was going on, and then when there was a complaint, did nothing to protect these individuals from, the wrath of the manager they complained against. Those are the types of things where, looking at that, it's just, the company did something, but they didn't really do best practices for, what you do with respect to.
I know I'm jumping ahead to kind of the punchline of the ending here for what employers should do, but I feel like we shouldn't go any further without just saying it is your legal responsibility as an employer to provide a safe work environment, and it is your ethical and best practice legal advice here. They have to take all these things serious. So even if you think as the employer, oh, there's nothing egregious going on here, regardless if it's race, gender, whatever the topic is, you have to investigate, right? And you can't show priority to the people who are already in the job, right? So it could turn out to be that it was good, healthy joking. It could turn out to be more. And if you can't demonstrate that you put a full-throated effort into figuring it out, trying to remedy it, putting solutions in place, whether that's disciplining other employees, terminating other employees, coaching, you have to be able to document what you did in response, just from a legalistic perspective of the employer, right?
Yeah, absolutely, right. As we'll get to in a bit, like you mentioned, right, I think a large part of this is how does a company respond to complaints, because that's typically when we're running into constructive discharge type issues when like we said earlier, there are two parts, right? The conduct needs to be intolerable, and the company should be aware of it, right? Because the company is either aware of it or they're intentionally doing it. And here the law will essentially treat those two things as the same, right? The company intentionally forcing the employee out, or the company sitting back and watching a supervisor make conditions so bad that they quit, are going to be looked at, in the same way. So yeah, a lot of this is, what do we do when we get a complaint? We document it, we investigate. And one part that shouldn't be forgotten about is how we protect the person who made a complaint.
Right.
Most of the time, we may tell workers that if you make a complaint, we'll keep it confidential to the extent possible, but we cannot promise full confidentiality. And so often the person who's subject to the complaint, they obviously find out about it because they're part of the investigation, and it's important to make sure that that person or others who are friendly with the accused are not then taking action against the accuser, because again, the company can be held to have acted even if it's just aware of what may be going on. So we want to foster a culture of raising complaints and foster a culture of no retaliation.
What's going through my mind, Brian,
again,
is
that's not.
So I want you to help clarify the intolerable conditions that the company creates versus employees. Is there even a difference? I think the punchline is going to be it's one of the same. But I keep coming back to nobody on this call probably sees themselves as creating a toxic, racist culture. They probably don't see themselves as creating a sexist culture with a bunch of catcalling. Those are the obvious things. Okay, how does this apply to me? But I mean, I firsthand have witnessed, I'd say, good businesses and good business owners. I know a construction company where there may not be intimidation and hazing of the new guy on the job site, but they sure aren't helpful, and it can be pretty toxic. You can cut the air with a knife because they're going to make the new guy prove that he can handle the job, and is he tough enough to be here? I've seen a hair salon that the new front desk person got a really pretty, dare I say, rough treatment of almost no treatment. Clearly crossed arms. You're going to have to prove it to me to see if you're good enough to work here. I think that's actually quite common, and probably a lot of employers can relate to that. Where does that sit in this continuum of an intolerable workplace?
Yeah, so you make a great point. And so I think number one, to be clear, for a constructive discharge, we're talking about, not just a general unpleasant workplace. Although I think in all the instances you mentioned, I think those are part of a culture that can be problematic, and even if not related to a discrimination or constructive discharge claim, those probably are problems and eventually could, seep into an area like this. Because when you have conditions like that, where, there are cliques, or, there are, people being difficult on others for really, no reason, then again, if we have the basis of some hostile work environment claim, and then, so that same guy who's coming to the construction site and he's new and they're giving you a tough time. Well, maybe he happens also to be gay. And now there are people both making, sexual orientation comments towards him. And, they might think those are just, regular jokes. And, maybe the tough time they're giving him has nothing to do with that, but it has everything to do with him just being the new guy. But now that's all tied together.
Right.
And so from from that employee's perspective, this might be developing a work environment that becomes intolerable. Now, again, most courts are going to find that it has to go on for some time and be quite serious. But yeah, I mean, look, minimally, we could be talking about hostile work environments that might not raise to the level of the unpleasant conditions that lead to the constructive discharge. But I think there's a whole nother line of cases where companies kind of put employees in a position, and this can be something where your managers are saying things getting the company in trouble, where these are the inevitable termination cases where basically an employee resigns in the face of an impending inevitable firing. So for example, we have a court found that multiple threats are typically included in needed for this, but that where a company presented an employee with a resignation letter and told them to sign it, and that if you don't sign this, we're going to fire you and your career is ruined. Well, that's likely going to lead to, a constructive discharge claim, because you're not leaving them with many options there. So again, in this area is sometimes, it's, the employer. And look, I can see areas where, and I've seen these situations, right? Someone complains about discrimination or hostile work environment, an investigation is done, and then, HR or someone else is talking to the employee, and we're asking, look, we've identified, some issues that you've had, but there are also some performance or behavioral issues, and you start talking about maybe whether they're cut out for this, and maybe it's best if we just, go our separate ways. And you have to be careful, because if there are comments, made to this individual that, look, we're probably getting rid of you at the end of, this investigation, or, something like that, they might be left in a situation where they think, they have to resign because a termination is in the books. The courts might not always rule that way, but since an employee isn't always right to assume the worst, but I think whenever we're talking to an employee about termination or improving conduct, it's important to make sure managers don't say things that are going to be taken as you're getting fired. Where we're so for instance, there's some cases I can give, in one case, an employee's supervisors, yelled at her in insulting terms during coaching sessions, right? So those were coaching sessions designed to improve performance. Instead, they're, in the coaching sessions, they're degrading her. And they make comments, her supervisors are making comments. Do you think you're going to outlive us? There's no hope for you. There's no chance you're going to be here. They told her, she was too expensive as an employee. And in reality, the facts showed that this was actually a good worker. And so, in that situation, a reasonable person in that employee's shoes could infer from that situation and this onslaught of criticism and attack that, hey, I'm not going to be here, at the end of this. I need to, resign. And so,
And
sometimes
I've seen
what
cases
forces
like
them.
in I've seen cases like in sales where the sales manager puts the rep on a performance improvement plan, a PIP, um, because they're not, hitting their sales quotas. But then at the same time, I'm restrict, say, their territory or the products that they can sell, or remove their discounting authority because they're not good enough to handle it, and we need to make sure we're going to give the good leads to people who can close it. Meanwhile, creating an unequal playing field for the rep that you're supposedly trying to improve. But my question for you, and that sounds like an obvious thing you probably shouldn't do. My question for you is and I'm trying to be as humane about this as possible, but thinking as an employer, you'd be better off if you're an at-will state, just terminating the person, saying, hey, you're not meeting your quota. This isn't working out. We need the revenue that comes from your sales pays everybody else's salary here. We're going to have to let you go. You'd be better off doing that than you would putting someone on a PIP and then holding back their ability to succeed, right?
Yeah, exactly. And, that's where this goes because, typically the constructive discharge doctrine assumes that the company wants this employee out. And instead of firing them based on either legitimate or non-legitimate reasons, they just make, employment so bad so that the employee quits. And then, the company can say, hey, look, we never fired this person. So yeah, I think absolutely, this goes back to, how do we discipline people? What's the proper way to discipline? What's the proper way to terminate? Building that record. Even if you have someone who has complained about, a hostile work environment or discrimination, they should still be performing as expected. So, there are two parts to that. If there's ever a complaint like that, you investigate it and you document that investigation. But at the same time, that employee still needs to perform. So if you have, employment, performance related issues, you can still, counsel someone on that if they've made a complaint. You don't just need to start pushing them out and hope it all just ends well. Is, what sometimes I think employers are thinking that, if we can just get this person out, things will be okay. And it doesn't necessarily work that way. But I think one way that, companies can really help avoid these types of claims, both, factually and legally, is, to have a mechanism for employees to, complain and get help. Right. So courts often find that the availability of a grievance or complaint procedure, will, avoid this type of claim because if the employee had an avenue they could go through to seek redress for these, so-called intolerable, conditions, but they didn't take advantage of it prior to their resignation, then the court will typically find that, it's not a constructive discharge. So I can give you a few examples to illustrate this.
Yeah, please.
You know, so one would be finding that you have in the union context, a union member could have sought a hearing before being terminated, right? There's often in the union context a grievance procedure, and if an employee doesn't go through that grievance procedure, can they really say, hey, I would have been terminated, or things were so bad? So typically, they will have to do that. Even HR, complaint procedures, for example, in one case, the court found that the plaintiff's demotion didn't result in a constructive discharge because this employee was aware of the company's complaint resolution procedures and made no complaint to HR regarding discrimination or mistreatment. So, like we said, that knowledge, that intention requirement for a constructive discharge, that's where a company can really save itself. Where the majority of constructive discharge cases where the court finds there is one, involve companies that had knowledge. Or should have had knowledge of the situation and either didn't do anything or went the wrong way. So, even assuming, everyone who's listening, none of these companies are going to intentionally do the wrong thing. Inaction alone can lead to a constructive discharge claim. If there's a complaint and the company, does nothing. So, that complaint process, having a robust, complaint procedure, in the handbook is so important. I know, Mike, on various times when we've spoken, we've discussed, complaint procedures require, having at least, two, if not more people someone can complain to, because, what do I do if it says to complain to HR, but HR is the one harassing me?
Right.
I have, I'm litigating a case right now with that very situation where, HR is alleged to be the bad actor, and, where was the employee supposed to go? To HR. So, complaint procedures that, provide a very specific way of going about things are great, but we also want to make sure there's some flexibility to those in case, someone involved in that is the actual, bad actor. So companies should really, take that, foster a culture of, complaints. That doesn't mean we just want, frivolous complaints, but employees bring issues to HR, to management is good for a company, right? You should know if there are issues. You should know what's going on, and that provides the company with the opportunity to fix things before they rise to the level of, an actionable claim or, a potential constructive discharge because of something a supervisor, is doing unbeknownst to the company.
Yeah, I mean, it might sound like a broken drum, but I mean, the punchline and the answer, the solution in almost every topic we discuss in this weekly show is obviously following the law, but it's communication, it's transparency, and it's good processes. It starts with an employee handbook. Here are policies and procedures. Then it's a job description. Here's what's expected of you, and here's what's expected of others like you. When there's a problem, here's how we're going to handle that problem. It's as simple as that. Advocate on the side of the business and the employee. Create a culture that is pro-employee, where they feel listened to and heard. But you also have standards that you can hold performance up against. But to do that, you have to have them in writing. You have to have job descriptions. You have to have employee handbooks. You have to have processes for handling grievances, for handling all these things, coaching, termination, promotion, all this thing. These are the best practices of HR, right? Because I just think about one of the problems if I'm an employer, especially a small business, I want to know the rules, right? And just like we're talking about having employee handbooks and job descriptions and whatnot, it sounds so simple, but you're providing the roadmap and the rules for your employees. Unfortunately, as the employer, it's not quite as clear for us, right? You've got really clear discrimination. You can't discriminate based on age, race, gender, sexual orientation, etc. There are some things about HR laws that are super black and white, but here's the case of intolerable workforce. By definition, these are gray areas, which means you have to err on the side of the employee, right? If you're in front of a judge and you can say, here's all of my extemporaneous notes, here's our policy, here's our procedures, here's the meetings that we have, here's your evidence, here's your testimony that says, boy, this looks really bad. We did our best, and let me prove to you why. Judges are human beings. They're gonna, unless you're clearly out of bounds, you're probably in pretty good shape. You might have some legal fees to defend, but if you don't have any of that documentation, it is truly your word against that person's.
Yeah, absolutely. And that's where, these good HR practices, I mean, not only do they help you combat the underlying discrimination claim, they'll help you combat, a constructive discharge claim. Because look, the way I look at it at its base is that if there really is a constructive discharge, then that represents, a a full, failure in HR practices, that either, you have a, rogue manager or rogue supervisor that, was not reeled in by the company, or, the practice goes, to, the heart of what the company is doing, and, there needs to be, a culture shift. So,
Brian,
these are
I,
situations where, yeah.
I have a use case question for you. Sorry to cut you off. I guess it kind of goes back to this word intolerable. So, what about changes in schedule? If you're a temporary employee working for a retailer, back when malls were still a thing, they seem to be disappearing pretty quickly here. You expected your employment was going to be from middle of November through December 24th or 5th, and then you go away. But I just know, having kids growing up and with retail jobs and stuff, they don't tell you you're fired. They simply just stop scheduling you, but they keep scheduling their best employees. Talk to me about scheduling, and then just simply not scheduling, because I think there's some potential ramifications there.
Yeah. So I think, I guess we'd put these under what we would call maybe a forced resignation, where, even though they're not being terminated, right, we're pushing them out through some type of employment change. So I guess, let's start that, in the United States, in almost every single state, we have at-will employment. And so, whether, employees can be terminated for any reason or no reason, just nothing discriminatory. And I mean, really, the law doesn't even govern being civil, right? We can be horrible employers, just nothing, crossing the line into, discrimination on protected categories. So, it should follow that, a company can take actions like, for instance, a schedule change that may have the effect of a termination, without any repercussions. Now, obviously, there's a caveat to that as the company needs to be acting with, legitimate business reasons. So, I can see the situation where, right, we have a scheduling change, across the board that affects, everyone. And okay, that's something where the company can likely show, this was applied indiscriminately. It applies to everyone. We simply are changing these times. And look, if it doesn't work for employee A, and she has to resign, as long as, there's nothing, in terms of, the decision to include, employee A in that group that's discriminatory. These types of, scheduling changes, can be fine. But, at the same time, changes in, scheduling where, we might be effectively laying people off, can lead to issues, right? For example, I can, give you an example where, I had this happen in a case where, the company, after it had, one of the supervisors was alleged to have, sexually harassed an employee. And after that, the supervisor changed that employee's schedule to a schedule that the supervisor knew the employee couldn't work because of childcare issues. Yeah. So what happened next? No one else in the company knew that, only the supervisor. And so what happened next? The employee was forced to, resign because she couldn't work those new hours. And now that employer is dealing with a constructive discharge claim. Because a lot of it goes to, again, how is it tied into that underlying, discrimination, hostile work environment claim? In this case, the plaintiff's alleging it is, tied into that because, the manager did that to get her, as, retaliation, based on making a complaint. So, yeah, the same change in scheduling or reduction in hours, if done on a consistent basis across a group of the workforce, can be legitimate, non-discriminatory. But if done as part of a campaign against someone, could also could on the other hand lead to a constructive discharge claim. So I think whenever a company is looking to like you said, change in scheduling, or maybe an across the board reduction in hours, or different types of changes to a workforce, they should examine how is this going to impact people? Are there any people we have existing issues with that we should make considerations for? But I mean, look, the general rule is the company can, act with legitimate business reasons and change conditions of employment. And if that forces an employee into a, I have no choice but to quit scenario because they can't work under those new terms, that's not unlawful. To be clear, that's not unlawful. So, an employer can do that. But again, the caveat being, if it sounds like any of those other situations we were discussing above, where, a condition is being changed based on, a complaint or as part of, some other, mistreatment of the employee, that's when we really run into problems.
Brian, I'm assuming forced resignations, constructive discharge, these in courts, they probably go hand in glove with retaliation. Is that pretty common?
Yeah, exactly. Oftentimes they will. Because, I mean, look, so many times when we have a hostile work environment or a discrimination claim, we have a retaliation claim as well. But, here with constructive discharge, especially because one of the requirements is that the employer knows of the conduct or is aware of it or is intentionally taking this activity. There's sometimes the very same action that leads to the constructive discharge claim will also lead to the retaliation claim as well. So yeah, they go hand in hand. And like I said before, same thing with hostile work environment, but again, a constructive discharge is kind of, so to speak, a hostile working environment claim on steroids, right? There's something else there as well.
Yeah, right. We haven't touched on unemployment insurance here. It's probably a whole that we could spend another hour on just that topic. I do think that I know that there are some employers will take pride. I hate to even say it that way because I know some people are very comfortable putting people in uncomfortable situations. They'll take pride of, no, I'll make them quit before I fire them because I don't want to take the unemployment claim. What role do you think that motive plays here in coach people how badly that can backfire on them?
Yeah. So I guess first I would say I understand that aspect because at least here in New York, right there, and most places, the Department of Labor, whoever is determining the unemployment claims, is looking at is this a termination, which potentially they can receive benefits, or a voluntary resignation, which typically does not entitle one to unemployment benefits. So yeah, it can be an area where an employer is trying to save on unemployment charges. Again, an unemployment hearing may be had, and they will address some of these issues to determine if it was really if the employee was forced to resign or not. They're not going to go into the same level of detail that a court determining a discrimination claim might, but they are aware of these issues, and just because someone quit, if they allege it was because of unlawful work conditions, they might still be entitled to benefits. But as you noted, the real question is it worth it? Most likely not. the amount that a company gets charged for, an additional terminated employee on their unemployment insurance is typically very low. Obviously, that depends on the state, and it depends how many employees have been terminated within some period of time and their wages. But in the end, potentially opening up the company to a constructive discharge claim over the issue of a unemployment claim, not worth it at all. So if that's the rationale, I would leave, put that aside, because the constructive discharge claim can be, much more disastrous for a company than a single unemployment claim.
I want you to speak to that more, Brandon. So there's obviously a continuum of company behavior from really, really well documented procedures and policies and handbooks and job descriptions and escalation processes to, hey, we're just a family here, and we don't take ourselves too seriously, and there's no documentation. There's a continuum of exposure you leave yourself with those choices you make. But there's also then the continuum of level of egregiousness, right? Of the claim. And sometimes a judge might throw this out and say, this is silly, that, you're wrong. This is not a discriminatory situation. This is not a hostile work environment, that, suck it up, buttercup. And the other end of the continuum is going to be, employer was clearly in the wrong here. At the minimum, even if the employer is in the right, there's legal costs to defend. And then in the high end, can you kind of just, I don't want to scare people unnecessarily, but paint a picture for what cost looks like from a cost to defend, best case scenario, to what does a court do? Do they say you must give the person their job back and now you got to deal with all that? Do they say it's a year's wages, 10 years wages? What does that look like?
Right. So, I think, look, the costs we're dealing with are going, just broad categories are going to be, if you're hit with a claim, discrimination claim, it's going to be your own attorney's fees. And then what the other side can recover, which will be their own attorney's fees under most statutes, back wages, which would be, the difference in what they earned after they quit or were fired, up to, the time of trial, as well as, potential, front pay if they're not able to find, comparable work, as well as.
Just to be clear though, if you win, the minimum is your attorney's fees, right? If you lose, it's probably your.
Right. Yep.
But if you lose,
and that's why,
it's and.
Right. And that's the guiding principle. When you wind up in a litigation, you are assured of your own attorney's costs. So that's a minimum. So oftentimes, every case is different, right? And it depends what, venue we're in, whether it's, federal court or an agency. But, let's just say, for example, in a discrimination case, these are very factual, highly factual cases. Oftentimes, a summary judgment decision, which means we would avoid trial, is not in the cards because the facts are in dispute. And so, we're talking, potential, high 5-figure and into the 6-figure costs for just the company's own fees, which, no doubt leads companies often to early settlements where, instead of paying your fees, you're going to pay something to the other side. But, either way, it's an expensive process. So, these aren't the situations you want to be in. You want to be in the situation where you hear of something at the workplace and you immediately handle it, and you avoid these. You handle things in-house. And, that doesn't mean, sweeping them under the rug. That means handling them appropriately so that, people are satisfied with how the company is acting. And I think, that's most important because, there's exposure. And look, if we're talking about a constructive discharge, then typically, the court is going to consider the conduct pretty egregious. It's probably a case where punitive damages could be available, which are, damages the judge or jury might impose just as punishment on the company for engaging in such bad acts. So these discrimination cases can easily be six figures into seven figures, and so the cost of the right HR practices are much less. And the avoidance of those things allows the company to focus on what it should be focused on, its profit making activities or other type of things.
Let's recap on that, because the title of this show today is Avoid Wrongful Termination Lawsuits. What is constructive discharge? Spent a lot of time talking about what is and is not and all the nuance of constructive discharge. At the end of the day is, what's your guidance to employers in this context? How to avoid all this from happening in the first place?
Yeah. So absolutely. So I think, the first step would be, if there's ever a complaint of, inappropriate conduct, whether, HR thinks it rises to the level of discrimination or harassment, or even something smaller, it's so important to investigate and document that investigation, right? Because even these things that don't quite, turn into actionable conduct, it's still good to investigate, because as a company, you want employees to be comfortable to come forward and make complaints. You want them to understand that their complaints are going to be taken seriously and acted upon. And so I think setting that culture is so important. And, where does that start? As I would say, a policy, right? You want to have, minimally, the EEO policy. And then, I often recommend, even having a standalone anti-retaliation policy, right? That, that kind of shows how important the company takes this. And that anti-retaliation policy, we'll have the steps that the company will take. It'll explain, how a complaint should be made. It'll explain that you can make complaints without fear of reprisal. And like we mentioned earlier, it'll have that detailed structure for how to report a claim. And that'll include multiple people. Companies can even consider, anonymous hotlines. Some companies find that those are worthwhile, and that, it can help make employees comfortable to file complaints, if you otherwise, don't have, a culture where that's accepted. Another important aspect is training. While employee training is always important, I'm very big on management training, because, I think those are, managers are a key line of defense, as well as, one of our potential biggest issues in causing problems for the company. So I think, we want managers trained to understand, what protected activity is, what a complaint is, how to spot, harassment, how to spot, what's acceptable at work and what isn't, and then, how to report it. That, managers sometimes think, they see things, but if an employee doesn't say something, they don't have to say something. But really, managers should be our eyes and ears. So if they see something, they should know what to say, even if they don't have a complaint. And employees should understand, both especially managers, what the consequences are for engaging in, retaliation. So, a lot of this stuff, just reinforces things that you and I have discussed today. But again, you get to a place where people will come forward to the company, and then look, at that point, it's so important what the company does with it, right? Because what we see in a lot of these constructive discharge cases is that the company was aware of something and did nothing, like such as, that example when it returned, the accused, bad actor back to the workplace so that he could, continue working. So it's very important we establish a culture where we'll get these complaints, and then we take every complaint, seriously, document it, figure out what needs to be done. And, of course, Mike, where, we don't expect employers to know what to do in every situation. It's difficult. And by all means, you're going to run into situations that you haven't had before. And, that's where, having an Assure, for instance, that you can call one of their HR consultants to get advice, because the worst thing is to ignore these types of issues or to get it wrong in terms of the reaction. So, it's great. The first step is getting the complaint, knowing what's going on in the workplace, and then the next step is appropriately dealing with it and, reaching out for outside help if you're not equipped to, handle the situation, on your own.
Brian, I appreciate the plug. I guess all I'll say to our audience is that is exactly what it sure does, right? So you think back to the early 20th century, Upton Sinclair's The Jungle and the formation of unions and the protection, all the legal protection that happened over the following century. Obviously, protection shifting more and more to employees, not the employer. I personally believe that as the war for talent has hit Main Street and there's a genuine labor shortage, and if you study the macroeconomic trends of like birth rate, job participation rates, GDP, productivity per GDP, this labor shortage is here to stay. This is not the result of just a pandemic or an election cycle or a war. The world is facing a labor shortage, and we're going to continue to see and feel that. That said, the power goes to the employee. So this isn't just upon the responsibility, isn't just upon employers to follow the law from an HR perspective. If you don't have good employee practices, employee-centric practices, you're not going to be able to recruit and retain the talent that you need to succeed. So I really think that these things go hand in glove. The problem is most small employers can't afford a $90,000 or $110,000 a year SHRM certified HR professional, and that's where we come in, because you can do that for pennies on the dollar on a fractional basis. So if you want to learn more, everybody can hop on our website. Maybe 20 seconds, Brian. How is it that you personally and your firm can help clients if they're interested?
Sure. Well, Jackson Lewis, we're a nationwide employment defense law firm. We represent employers in all sorts of employment-related matters, running the gamut. Obviously, what I'm involved in a lot of is litigation, but we also do a lot of preventative work as well. Mike, thank you for having me on today, of course.
Yeah. As always, I learn a ton from you every time we talk. So until next time for you and I, Brian, and next time for our audience, we'll talk to everybody else next week. Thanks so much.